Next up on This Week in Law, I'm Denise Howell, and I'm joined by Matt Curtis and Andrew Rossow. We're going to talk about WannaCry and how you may want to cry if you're thinking that you're going to be able to sue the NSA or Microsoft over all of this. Uber is parsing customer data in very interesting, fine-grained ways, and we'll look into that in some detail. We'll tell you everything you need to know about what happened in yesterday's FCC net neutrality vote and everything you need to know about suing your date for texting in a movie. All this and more next on This Week in Law.
Netcasts you love.
From people you trust.
This is Twit.
Bandwidth for This Week in Law is provided by CashFly at CACHEFLY.com.
This is Twill, This Week in Law with Denise Howell, Mike Keyes, and Matt Curtis. Episode 386, recorded May 19th, 2017. Is being like Wine of Month Club. This episode of This Week in Law is brought to you by Betterment, a smart, easy-to-use, and less expensive way to invest for your financial future. Get 1 month managed free when you make an initial deposit of $10,000 or more at betterment.com/twill. Hi, folks. I'm Denise Howell, and you're joining us for This Week in Law. I'm really excited that you've joined us this week. We've got an excellent show teed up for you. There's been nothing going on whatsoever. We've got such a full rundown. I fear our ability to get through it, but we're going to try and do just that. And we have a great panel of folks here to help us understand all of this complicated and important stuff. I will tell you in advance, we're going to talk about some stuff that's not that uplifting, but we'll try and end the show on a somewhat more entertaining note, if at all possible. Anyway, before I scare you to death that we're going to have a downer, crazy show, let me introduce you to our wonderful panel. And that includes my co-host, Matt Curtis, who's a law student at Notre Dame. Hello, Matt.
Hi, great to be back. Made it through exams, so I get to come and play on Twill. So I'm excited.
Yay, congratulations. Good job. Wonderful to see you. My other co-host, Mike Keyes, is off this week, but joining us from Dayton, Ohio, is Andrew Rossow. He's a cyber attorney who focuses on the internet and intellectual property law and practices with Dayton lawyers. Hi, Drew.
Hi, Denise. Thank you for having me.
Great to have you. We know Drew through Lawyers Slack, and anyone who's interested in joining Lawyers Slack should look up Keith Lee. He is the gatekeeper for that wonderful Slack domain. And if you're a lawyer and you're interested in chatting in gregarious ways with other lawyers, definitely go check it out. So it's great to meet you in person.
Thank you. It's nice to meet you as well.
All right, so we're going to go right into it. We'll try not to scare you too badly, but, there's some scary stuff going on out there, and we're going to start looking at various crimes and justice issues that have been much in the news lately. I think we're going to start out with WannaCry, which has been much on our network this week. In fact, if you want to get into the weeds and nuts and bolts about how exactly WannaCry works and all of the details that are known, I'm sure, about why it was able to do what it was able to do, you should catch Steve Gibson and Leo Laporte on Security Now 612. You should also, I understand, I haven't seen this yet, but catch Padre SJ, Father Robert Ballister's show, Know How, from yesterday. That's episode 312, where he actually managed to infect himself on air with WannaCry. So if you want to see that, how that unfolded in real time, check out Know How from yesterday. But we will look at it more from the liability standpoint and try and figure out what sort of recourse there might be, in addition to emphasizing what you should do so that you're not troubled by WannaCry, and commiserate with you if you have been troubled by WannaCry. Why don't you tell us, for anyone who has been, out of the country or offline or whatever over the last several days, Drew, what WannaCry is?
Sure. WannaCry is a type of ransomware that has been modified from a exploit that the NSA had as a tool to Microsoft Windows, primarily the older versions. And for those of you who aren't familiar with what ransomware is a type of program that takes over a user's computer or device. In exchange for recovering their device or access to their device, they have to pay a ransom. And WannaCry was released, I believe, last week, based off an NSA tool that had been modified.
Right. And I actually was out of the country last Friday when this all broke, and was still hearing the ripples about how serious this was and widespread it was. And it certainly wasn't just localized to the U.S. So the interesting piece of this for us, looking at it from the legal standpoint, is, of course, if you have found yourself subject to this, whose fault is it? Is there some sort of recourse that you should have, or that you can and do have? Obviously, this is just one example of the great array of cybersecurity issues that are out there in the world. This is a particularly onerous one, and particularly terrifying one, I think, in lots of ways. As the Washington Post broke earlier this week on Tuesday, they are reporting that the NSA knew about this vulnerability in Windows for more than 5 years without saying anything to Microsoft about it, encouraging them to patch it. And also that there were individuals within the NSA who knew how bad this would be should Eternal Blue get out into the wild and exploited in precisely the way that it was and possibly still could be. Yet they didn't say anything to Microsoft until very recently, early this year, when Microsoft started addressing this issue and patching it for certain Windows users. The older versions of Windows, I'm afraid, were out in the cold until I think they've been patched now. Again, check in with Steve Gibson's show for all of the rundown on exactly what still needs to be locked down or concerning yourself with if you want to make sure that you don't get this. You wrote an article on that very issue, Drew, things that you can do to protect yourself against WannaCry. Do you know exactly what is still vulnerable, if anything?
Yes, and what's scary about this WannaCry ransomware is that it hit on a global level, and I think it caught almost everybody off guard, in that people are comfortable with what they use on a daily basis in terms of an operating system. And there's some people, unfortunately, that are still using the Windows XP platform, which is no longer supported with security patches, security updates. And in this situation, where you mentioned that the NSA had known for quite some time about this, they did, and based off the sources, there's a cost of releasing this type of patch and having the internal security teams look and see what the chances are of that tool being exploited. And I think that's another argument that's floating through the media, is that what could they have done to avoid this? And is it really NSA's fault versus Microsoft's? But to answer your question, make sure your system's upgraded. Windows 7, I believe, is the most stable or the oldest version of Microsoft that you should go back to. But Windows 7 and 10 have the patches available, and don't open anything you don't know. You have social engineering techniques where you'll receive an email or a link to something that sounds like something you'd be interested in or may have clicked before, whether it's something appearing from Target or Amazon, and that all it takes is that click or that opening of an email to infect your computer.
So, Matt, there have been plenty of businesses and individuals impacted by this. I think I saw the number over 200,000 people who'd been subject to the ransomware, who had been held hostage by it. From the liability standpoint, let's try and break this down. I will not at all be surprised to see lawsuits flowing toward Microsoft about this. Suing the NSA is a little bit more problematic given government immunity, but not, I think, entirely off the table. There are exceptions to government immunity, and if it can be demonstrated that a government official was, I think different standards apply, but if you can show that there was reckless disregard for public safety, I think you could have a good shot at bringing a suit against the NSA. But Matt, I'm interested too in people who've chosen, for whatever reason, they like Windows XP, it's stable, it's too expensive to upgrade, inertia, whatever reason, they've chosen to keep an older operating system running either on their personal devices or on their business systems. Is this something, how do you think that all factors into the liability equation?
So I think that in a general circumstance, if you're not updating, if you're not following the terms and procedures of your product, I remember a couple weeks before I came on, you guys had a podcast about the loss of ownership. But part of that is that these are license agreements that you're entering into with other companies, and so to hold them liable for a product that's being continually upgraded when you're not upgrading it, I think it gets a lot harder. I think they're aided by the fact that so many people this happened to. So in order to bring a class action, they may be able to, because the number of individuals who did not upgrade to the system show that this is common. This isn't a one-off thing. But I still think it's really difficult. I really don't think they're going to be able to get at the NSA, especially since the NSA is directed outward. I think for a public policy reasons, that's not going to happen. But I think it's hard to even bring a suit against Microsoft.
Yeah, you're probably right there. I mean, really, if the NSA can't keep its own property from being hacked and stolen and released and exploited, I don't know how we can look to other law enforcement and say, you should be doing a better job protecting the NSA. Is that what we should be thinking, Drew?
It's hard to say because, we're supposed to put so much dependence on, the higher ups in the government to keep us safe, to protect us. But at the same time, we have our own responsibility to make sure we're not doing anything to put us in those situations. And I have to agree with Matt. I think it's going to be very difficult to get to the NSA and even Microsoft in those situations, because then you have to start looking at the type of due diligence that these people were engaging with and engaging in. I think the easiest fallback is, what can you as a user or consumer do to to protect yourself and make sure you're not putting yourself in that type of position.
So one of the things that you hit on in your piece, Drew, is, of course, if you're not really familiar with all of this and the dynamics of it, you might be tempted to pay the ransom just to, make it go away. Why shouldn't people do that?
It's that saying of, can you really trust anybody? And it's a very negative way to think about things. But in the cyberspace world and in cyber world, you can't really trust anybody, and you never know what's going to happen. And if you start shelling out money in hopes that you're going to get your files back or your data back, what's to say that you're going to get them back at all of them back? And even that, if you're willing to pay once, why wouldn't you be willing to pay again? And you don't know what these attackers or hacker groups have put on your computer to either continue that, effect or the accessing your computer. And it sets a very bad precedent. As much as you want to get your stuff back, there's other ways to go about it. And that goes in lines with making sure you as an individual or your business has a good data policy in place.
Well, I think maybe the second thing you would think about if you were subject to something like this and you weren't terribly conversant in all of the ins and outs of, what this was and how you deal with it, you might think about paying the ransom. Hopefully next you would think about calling the police. What's your take on what happens when people do that?
It's not too often to my understanding that people actually do that, because I don't think people know if there is a way to resolve that. But I think it is a good step. It can't hurt to call law enforcement and say, hey, here's what happened. I paid this money. Can you make a record of this? And most of the time, people don't know who the other person is on the side of the computer or the one who has access to their computer. And that's part of the problem of filing a police report is who's the other person. And, there's times where I've known people that take it to the Best Buy Geek Squad or some sort of PC repair place where they're able to at least extract enough information from your device to tell you, hey, here's what's going on, here's what you need to do to protect and transfer your files. But, it never hurts to report it.
Right. The EFF has written, go ahead, Matt, before I go on to this.
Yeah, you're also talking about businesses who their incentives don't line up with necessarily telling the police, because they've just had hospitals and businesses that have credit card information. These businesses, they're on the hook in some sense for their own security breaches, and therefore paying them, especially when it's time sensitive information, is oftentimes going to look like the best option. Not at all advising that, but the incentive doesn't line up for compliance in alerting authorities.
Right, and that's a really good point, because if your data has been compromised and you're a business, there are many situations where you're obligated by law to let your customers know about this quickly and let them take remedial steps or provide remedial steps for them to prevent identity theft or whatever they can, try to stop the flood from coming out of the dike from the fact that the data you're maintaining for them has been compromised. So you're right. The incentives may be tricky, but it's very tricky as a business. If you don't do what you're required to do under law, you're in really hot water then. So you need as a business to be conscious of, if you've been subject to something like this, immediately get your legal team on board and doing the right things to give the notices you need to do, and hopefully involving law enforcement to make you one of the many who are identified as having been hit by whatever you've been hit by. The EFF is the EFF wants to cry. Everyone wants to cry over this, but particularly the patching problem is what they've written about, and how there is what they've quoted as a toxic hell stew of known vulnerabilities that simply aren't patched, or in some cases can't be patched, and are posing this huge threat to our infrastructures. And they point out that President Trump, when he was campaigning, I'm quoting from EFF here, expressed tremendous concern about national cybersecurity weaknesses, stating the scope of our cybersecurity problem is enormous. Our government, our businesses, our trade secrets, and our citizens' most sensitive information are all facing constant cyber attacks. And what EFF would like to see the administration do to follow through on that is to place a greater emphasis on funding defensive security research. Research into defensive methods and better strategies for patching systems is less sexy, they write, than overhyped zero-day vulnerabilities or imaginary cyber missiles, but it is the surest path to a more secure internet for everyone. So from a law and policy standpoint, that's something that people should be thinking about, getting in touch with their representatives in response to this and saying, hey, we've got to put a stop to this. And as we're talking through right now on the show, your remedies, if this happens to you, are not great. Paying the ransom, certainly not something you should do. Getting in touch with law enforcement, I would say yes, by all means, and know your responsibilities if you're a business as well, as to how you have to address the fact that you've been compromised. But I also get the feeling that, again, coming back to, if the NSA can be stolen from and basically duped in this way, to the detriment of all the rest of us, to look to law enforcement in our current state, I think they're kind of playing catch up at this point. They're not out ahead of this problem in the way we'd all like them to be. So I tend to agree with the AFF that we need to be devoting tax dollars toward addressing this problem on a broad scale. What do you think, Matt?
I think that this is like a basic problem of almost all, cyber warfare is just another form of warfare, and the cost of defense are always higher than the cost of attack. And the cost of attacking a network system, it can be done by anybody and anywhere. Obviously, they have to have the skills, but anything we can do to the defense, I think we have to recognize that it's an individual thing and a system-wide thing. Because the backups things, the sort of easy things that you have to do that we put in place checks for, whether it's so that users can keep the old systems as they want them. They have to realize that there's cost and benefits to that as well. But I don't think that I don't think it matters how much. I think that putting money towards this is a good thing, but ultimately there's no 100% success rate in this situation.
Right. And one point I wanted to come back to that I asked you about earlier, Matt, is if, I think we all probably agree that suing the NSA would be a really tough road here to try and recoup any losses. Microsoft, possibly, but, they didn't know. Should they have known? That would be should they have known on their own? Are they liable for having a buggy operating system? I think people have tried to sue them over the years for that, a vulnerable operating system, and haven't had a lot of success. So, it's just one of those things that you accept and that is disclaimed like crazy when you license and use software, that it's not perfect and that it's a work in progress, and that you as the user have some responsibility to make sure that you're upgrading and patching. And that's bringing me back to the point of the people and businesses who do choose to use older versions of an operating system. I think when push came to shove in a lawsuit like that, would find themselves subject to pretty strong arguments that, hey, we've told you that operating system isn't secure any longer and isn't supported, and you're using it at your own risk. So too bad. Anybody disagree with that, Drew?
I think with the patching of the software, there's only so much Microsoft can do, and it's a thin line no matter what, because, there's always something on both sides that individuals can do. But when it comes to patching, kind of like what Matt said, is that there's a cost-benefit analysis to all of this. And how much is the NSA or the Cyber Defense Department willing to allocate towards the offensive part of cyber versus the defensive side of cyber? And I believe one of the articles you had put up a few minutes ago, I forget the name of it, but it stated that 90% of funds allocated towards cyber defense are on the offensive, whereas the other 10 are allocated towards the defensive. But, it's always nice to keep your system upgraded, and I think everybody has a responsibility, and it's hard to allocate what type of percentage goes to whom.
Right, and I guess the last thing we should cover in this topic is that the fact that it's been identified and patched doesn't mean that it's the end of the story. What might happen next, Drew?
There's always something bigger and more, I guess, effective, you could say. And if it's not WannaCry today, it's WannaScream or whatever else may come about. And, there's always some sort of exploit in any program. And there's no perfect software. There's no perfect coding. But, all we can hope for is that operating systems such as Microsoft and Apple and Linux, they have the ability to inform its consumers and its users of potential threats. And in this situation, it was scary because both the NSA and Microsoft knew ahead of time, and the length of time it took to release the patch was, arguably a problem.
Mm-hmm. The other sort of hysterical part of all of this is the shadow brokers, the folks who are holding people hostage and exploiting Eternal Blue, are not stopping. They say they've got more exploits. The initial round of exploits they released was last August, and the government has been taking them seriously and trying to deal with them ever since. But they're now making a cottage industry out of this. They have a newsletter, I guess, that announced that they're launching a new monthly subscription model. And this is coming from Ars Technica. And by the way, you can access all of our source reporting on this by going to our topic list for the show. You can find that at tagpacker.com/user/thisweekinlaw. We're at episode 386 this week. Also, if you go to Flipboard user D Howell, I have a magazine there that I keep for the show, and all of these stories are in it. But this dispatch from the shadow brokers, again from Ars Technica, written in the group's characteristically exaggerated broken English, stated, is being like Wine of Month Club. Each month, peoples can be paying membership fee, then getting members only data dump each month. What members doing with data after is up to members. So who knows if they are affecting a crazy accent or this is the way they actually write out English phrases. I'm guessing the former, but they're trying to syndicate this out and make a whole business out of the data that has flowed out of, been stolen from the NSA. So watch this space. I think that law enforcement is certainly pursuing them with a vengeance at this point, but we'll see how well they do. We're going to move on and talk about yet another somewhat nefarious way that you could buy and sell illegal data in just a moment. But just to close out this topic, Matt, anything to add?
No, it was just a very dystopian view of the world that kind of we live in, and this is just a new wave of piracy. It's been around forever, and it's going to continue. But it was crazy that they went with the Wine of the Month slogan, and they may need to hire you as their spokesperson, though. I don't know.
Yeah, I don't know if I'm ready or desperate enough to go there just yet. Drew, anything you want to add?
You know, it's a common phrase that it's not if it happens, it's when. And unfortunately, that's the motto a lot of folks in the cyber industry live by. And it's always, what can we do better? And there certainly is going to be more, and there's going to be more ways to defend against it. Right.
So, learning from history is the best way, I guess, to protect folks moving forward. And one huge story that we covered for years as it was unfolding is now a book by the wonderful writer Nick Bilton. I'm very anxious to read the book. It is called American Kingpin. There's a subtitle too. Let me pull that up. The Epic Hunt for the Criminal Mastermind Behind Silk Road. And it is about Ross Ulbricht, obviously. And it looks like Nick has really done a deep dive here. So far, I've only read, and I've linked to in our discussion points, an excerpt in Vanity Fair from his book, which I encourage you all to go check out if you're not remembering. It was a couple years ago now, actually more than a couple years ago, 2012, 2013, I think this was all unfolding when Ross Ulbricht and Silk Road were being pursued by law enforcement with a vengeance. And there, they actually managed to apprehend him based on I think they found an IP address that was associated with his Dread Pirate Roberts nick that he was using on Silk Road, and they tracked him down to I think it was a library. That's what was in the Vanity Fair piece in San Francisco, where he was operating the site and doing various things like. Again, this book looks like it's going to be a great read. Deciding whether he was going to put hits on people who were attempting to undermine the site. So I think, if you were following along with the drama at the time, you remember some of that. But what's really interesting, I think, about Nick's take on the whole story is a couple of things. Number one, that Ross Ulbricht, who, by the way, is in prison pending appeals of the double life terms with which he has been sentenced. Nick sort of comes down on the side of Ross Ulbricht never intended to be a bad guy, and that there's not too great a difference between Ross Ulbricht and CEOs of things like Uber and Airbnb, that these business models too. Here, let me read from the article here to give you where I'm going. By the time Ulbricht arrived in San Francisco, Uber and Airbnb had already staked their entire multi-billion-dollar business models on defying existing regulations, from what constituted a hotel room to who could offer a taxi ride. They were not only in heated battles with various unions, but also in litigation with city governments. This new generation of Randian founders didn't ask for permission. They just took it. And he has a quote by Ayn Rand in the piece that he says was sort of a mantra for Ross Ulbricht. He also writes, "This may be what Pablo Escobar looks like in the internet age." And he also concludes, the more people I spoke to, the more I read of Ulbricht's diaries and chat logs and site comments, among other things, the more I realized that he had devolved in the exact same way as other tech entrepreneurs. The main difference was that he had chosen drugs to disrupt rather than taxis, hotels, dating, or friendship, and that he had been held accountable for his decision to destroy other people's lives in order to protect his business, rather than being able to look the other way, as so many successful tech CEOs do. As all of this was unfolding, it never once occurred to me. I always felt like there was a significant difference between Silk Road and the Ubers and Airbnbs of the world. But maybe Nick's on to something here. Matt, what do you think?
I think that, the means and the methods in terms of what you have to do, like vertically to organize yourself in order to disrupt any industry, may be the same. But I think he just stretches it way too far. I think that you're talking about different faculties, and that the faculty of whether or not to kill somebody has to do with judgment but the execution of disrupting a business is very different. And maybe there's arguments for that. Having legal mechanisms to deal with drug issues would be a good thing, and I think that there is a good case for that. But he didn't have the judgment. He went out and killed people when he didn't like something. I think that he took it a little far. I do think that the same abilities and capacities can lead you very different ways. I think that's true of Nazi Germany. I think that's true of some of the things that we've done in the past too as a country. So, but I don't think that I think that the internet is a technology and a mindset of way of getting things done that does not make Airbnb and Silk Road the same.
Well, I don't know if he actually ever killed someone. Maybe IRC can remind us if they remember the details better. But what Nick has written about in the Vanity Fair excerpt is the botched attempt to go after one of his employees who was attempting to shake him down. And he definitely intended, went ahead and gave the go-ahead to put a hit on him, but he wound up being it was a law enforcement trap, and he didn't actually succeed, and that was eventually helped lead to his apprehension. So any thoughts on all of this, Andrew?
From the Spider-Man series, with great power comes great responsibility. I think the same, I'm a nerd. I think the same holds true with technology. I have to agree with Matt. I don't think it's the same thing with Uber and Airbnb versus Silk Road, and the decision and how to handle a disgruntled former employee who's putting the iron fist against you or on you. You have the decision-making ability to say, this is how I'm going to handle the situation. And while it may have initially started as a good idea, as a Silk Road platform, it's how the technology is used. And when it starts to become a success, and then the goal of the operation of the business starts to change because money flows in, it's same thing with that whole Breaking Bad show, which a lot of people can relate to, or at least compare an analysis to, is you don't always start down that same path.
Right. I think the main takeaway from the Nick Bilton excerpt is, the whole ask forgiveness, not permission mentality gets a little scary when critical personal data or even people's lives are at issue. And let's see, there was another great quote, I think, from this that involved self-driving cars. Yeah, here, let's see if I can find it real quick before we move on. Yeah, maybe it wasn't this piece.
It was just a great read, though.
Yeah.
And I look forward to getting the book as well, so.
Absolutely.
Yeah. I mean, I think his point is, when you can, yeah, here we go. Just found it. The generation that is building the technologies of tomorrow doesn't always think about how its creations can be manipulated in nefarious ways. Driverless cars will surely free us up to nap or watch a movie on our commutes, and they will likely reduce the number of automobile fatalities each year. But why would North Korea or Iran build a nuclear weapon when either can drive countless cars into one another at 100 miles per hour? The same terrorizing possibility is true for artificial intelligence gone rogue, biotechnology research, and even the next generation of social networks. So I think, he's arguing that we need to be paying attention to ethics and responsibility, maybe more than Silicon Valley has traditionally done. And it's a hard question because you don't get the kind of innovation and wonders that we have in our world without a lot of sort of breaking things first and picking up afterwards later. But move fast and break things, I think, is what I'm trying to say. But it's starting to get to the point where that could be pretty scary, and that's a good segue into our Internet of Things story for the week. Actually, it's not our only Internet of Things story for the week. We're going to talk about some more from the privacy front. But first, just have to give a heads up to anyone who has not seen the story about Reuben Paul, who is in 6th grade at school in Austin, Texas. He's 11 years old, and he went to a conference at the World Forum in The Hague, a conference of security experts and professionals, and just knocked their socks off. He brought an Internet of Things, internet-connected teddy bear with him to the conference, and went through some gymnastics on stage where he deployed his cuddly teddy bear, this is from The Guardian now, which connects to the cloud via Wi-Fi and Bluetooth to receive and transmit messages. Then he plugged his laptop into a Raspberry Pi device and scanned the hall for available Bluetooth devices. And to everyone's amazement, including his own, remember this is a room full of security professionals, suddenly downloaded dozens of numbers, including some of top officials. Then, using Python, he hacked into his bear via one of the numbers that he had just skimmed to turn on one of its lights and record a message from the audience. So he very tangibly demonstrated to these security professionals that something that we talk about on the show a lot, and that is that Internet of Things devices have a lot of vulnerabilities that may not have been thought about or patched. So he was able to show that quite concretely. Other great fact about Reuben Paul from this Guardian piece is just as a side note, he's the youngest American to have ever become a Shaolin Kung Fu black belt. So props to Reuben. He's quite a kid. Any thoughts, Andrew?
On the Kung Fu or the
on any of it?
I think it's amazing that somebody at that age has the sort of understanding of that technology, and I think it says a lot about the future of generations to come on, their ability to grasp concepts such as this. And I think this was a great thing that he's doing, and it's spreading awareness, and that any toy, any electronic device can be used against you, and while they may have a good purpose, it can always be shifted. And I think what he's done is just it's remarkable.
Right. His premise of his talk was that toys can be weaponized. So beware that teddy bear. Matt, anything to add?
Yeah, I think that just a plug for good parenting there. I think that they did that just seems like a great experience. And then when you look at like what is more vulnerable, something that has a lot that goes into it, that's multiplied a lot, or something like a kid's toy, and the kid's toy is going to be more vulnerable because there's just not as many protocols you're going to put in to make them safer and all of that. So I just think that's another reality of the world. Although I hope that people in general don't go after kids like that, but I'm probably living in a dream world there.
I sad to say, I think you may be. We're going to move on to some other internet-connected devices, and things they should or shouldn't be doing later on in the show. But before we get there, we'd like to thank our advertiser for this episode of This Week in Law, which is Betterment, the largest independent automatic investing service built to answer the question, what is the best way to invest my money? Betterment aims to make investing straightforward. Simply create an account, share your financial situation, and their advice platform will build a personalized portfolio for your goals and desired levels of risk. For each goal you set, retirement, house down payment, you determine how aggressive you'd like to be, and Betterment takes care of the underlying investments and can implement tax-saving strategies. Betterment's management fees are lower compared to traditional services, 0.25% on assets under management with the option to upgrade to 0.4 or 0.5% for access to a CFP or licensed financial expert. They only charge fees for the first $2 million invested. Any balance over $2 million is capped in the respective service tier. Everything Betterment does is designed to lower taxes and increase returns. Unlike traditional investment managers, Betterment automates advanced tax-saving strategies like asset location and tax loss harvesting. On average, Betterment's tax-coordinated portfolio can increase portfolio value by an estimated 15% over 30 years. Betterment can become your hub for tracking your wealth. Their interface gives you the ability to view outside investments so that you can view all your accounts in one place. Tracking your investments shouldn't be confusing or frustrating. Betterment's technology makes investing easier. As with everything in life, investing involves risk. Right now, get 1 month managed free when you make an initial deposit of $10,000 or more. To learn more, visit betterment.com/twill. That's betterment.com/twill. Betterment, investing made better. Thank you so much, Betterment, for your support of This Week in Law. And on that note, let's look at some privacy stories. In case you missed it, Facebook got slapped with a hefty fine in France. Also was found to be in violation of some Dutch privacy laws. Is in general struggling in the EU to get the privacy compliance folks there on its side. The fine that it was hit with in France is 150,000 euros, but that is poised to become in the next several years potentially much worse. Because this was under prior versions of the laws in the EU. Now they can issue fines of up to 3 million euros. And under regulations set to go into effect in 2018, privacy regulators can fine companies up to 4% of their global turnover. In Facebook's case, that could be a lot of money given that it earned $27.6 billion in revenue last year. Facebook is taking this all fairly in stride, saying, we take note of the decision and we respectfully disagree with it. So I think that $166,400, which is what 150,000 euros translates to, is kind of a slap on the wrist at this point. Facebook is making arguments that it should be only subject to rulings from Ireland's Data Protection Authority, since its European headquarters are in Dublin. And it's not said whether it will appeal this most recent fine, but the actions that resulted in this current statement that you're running afoul of EU privacy standards had to do with tracking users once they've left Facebook, tracking them around the web, and not here's exactly what they were complaining of. The decision said that Facebook had continued to collect sensitive data of the users without obtaining their explicit consent, and that it used cookies to track activity on third-party sites without providing clear and precise information to users. Also said the company did not demonstrate the need to retain user IP addresses all along the life of their account. So Facebook still doing things that the EU is not happy about, but taking note of the fact that they're not happy. Drew, anything you want to add to this?
Having not seen specifically a lot of the arguments or much of any other than, our data is being tracked. We don't know what they have access to. It's hard to say. I agree with you. I think it is a slap on the wrist in Facebook's eyes. I think everyone has a different type of argument in this, and I know we in the U.S. dealt with a similar situation. I think it might have been last year where Facebook hadn't fully disclosed, if I'm wrong, please correct me, hadn't fully disclosed the nature of the types of data that was being tracked and how to even view it. And I think Facebook, at least in the U.S., has taken strides to make users aware of how to download their data. And I'm not sure if that's available in the Europe's area or, at least regarding this transaction. But it's difficult to say.
Right. Just something to note that EU regulators are still struggling with how U.S.-based social networks and other tech companies are dealing with user data and using user data. Two more stories right along those same lines. Let's do the Uber one first. This was fascinating. Some really good reporting by Cash Hill, who's been a most welcome guest on our show several times. And hopefully we can get her back again soon to talk about this and other things. But she has a piece at Gizmodo about a lawsuit that's pending in San Francisco, a wrongful termination suit by a former Uber forensic investigator named Ward Spangenberg, if I'm saying his name right. And as Ward is trying to show the merits of his claims, some interesting documents are coming into court in the case. And I'm not sure if this was introduced by Spangenberg's lawyers or Uber's lawyers. I suspect the former, because it was only a matter of public record for 2 days before Uber was able to get the documents sealed, so they were no longer available. I'm afraid by then the genie was out of the bottle, though, and certainly Cash Hill got hold of them and wrote them up, and I'm sure others are paying close attention to what they say too. They're this huge database that shows you how Uber is parsing data about all of its users, how it's logging. Here's from the article: nearly every aspect of its interactions with customers, not just when you created your account, but where you were when you created your account for Spangenberg, an office on Battery Street in downtown San Francisco, and how quickly after creating that account you first called an Uber, and how long your account has been active down to the second. And much, much more. She calls it a near endless cascade of information, demonstrating the immense and granular effort Uber puts into logging every aspect of its interactions with customers. So definitely worth checking out. She writes too that the spreadsheet affirms that Uber knows its way around private information. It's a vivid reminder of the extreme asymmetry between the users who are simply interested in being able to hail a ride from point A to point B and the machines that are tracking them. And there's a tool available when you go to the Gizmodo article that enables you to search this database for the various data tags. And you can, search by GPS and see everything that's tagged to GPS. You can see whether it's keeping track of whether the devices accessing it are rooted. It's keeping track of just an incredibly, as she writes, granular set of information about, information about information. Would we call that metadata? About all of the data that it's keeping on customers. So super interesting little side result of a wrongful termination suit that's pending against Uber. One thing I should let folks know is Matt Curtis, who's been co-hosting along with me here for a while, had to run. He had an emergency come up at work, so he's not on the show anymore. So Drew and you and I are going to bring this in for a landing by ourselves. Sure. Why don't you, you're the one who I think added this to the rundown, did you not?
I think I did.
Yes. Do you have any further thoughts about this?
I think when it comes to it's different. This is a ride-sharing app, and I know what Uber's started was so conceptually new at the time and very convenient. And I think with that type of app, there's got to be a way to understand how to consistently make the service better and the application more, I guess, realistic. And again, where that line is between how much data is tracked and Uber's ability to, have access to it and then share it with the consumer. It's a gray line. And I believe that article where I found it, somebody used the term grayballing or, gray line. And it's scary, but at the same time, how do you expect a company to grow and become better if it doesn't fully understand its demographic? And I think it plays in both courts a little bit.
Well, grayball was just one of the tags that they could see from all of the information. And Uber's already up to its eyeballs in hot water about grayball, attempting to identify people who were government employees, regulators, attempting to check out, how the system was working and whether Uber was operating in ways that it was not supposed to be doing in places that it was not supposed to be doing, so that they could possibly dodge some of that investigation. Certainly that's something that pops up here. The other thing I thought was really interesting about the piece is that Cash Hill spoke with an Uber security spokesperson named, her last name is Ensign, and she pointed out that everything that's going on here is completely dealt with in Uber's terms of service, and all users agree to let Uber do this when they sign up. She says the material is based on a small set of things that are outlined in our terms of service. All of those signals are derivatives of IP address, payment info, device info, location, email, phone number, and account history. So, although all of those things sound maybe pretty innocuous when you're signing up for your ride-sharing service, what Cash Hill writes is, what's staggering is that Uber can do so much with just those 7 pieces of information.
Sure.
So just give some thought. First of all, be sure to read those terms of service or pay attention to people who are reading them about the services that you're using, and consider, just based on those 7 pieces of information that Uber is parsing here, what they can and do know about you and what they log. The other thing she points out is just that when you're doing this all in an automated way, that the information's just being logged and parsed, that it's creating a way more detailed profile on you. Here's what she writes. Uber's automated systems gather small and seemingly insignificant details persistently over time, material that would otherwise be forgotten or bore a human surveillant to death. So the fact that it's all automated, takes that death by boredom piece out of the equation, and makes a really detailed dossier on you that probably never occurred to users when they signed up to first hail their first Uber ride. So I said we were going to depress the hell out of people today, and I think we're achieving that well.
There we go. But no, it's always safe to read the terms of service, as lengthy as they are. Companies do their best to outline it, but there's always more behind. What does collecting your data mean? What does, tracking mean? And as this article explains, there's more behind those labels than meets the eye. And how far should they be able to go?
Right. So further to this, there's a lawsuit pending in California against Vizio about its smart TVs that you might not have heard of yet. But Eric Gardner, who's going to be on the show soon, we're getting a good date for him to come on. He's been on with us a bunch, and he writes the amazing Hollywood Reporter Esquire column, blog, wonderful bit of reporting that he does day in and day out for the Hollywood Reporter on entertainment and entertainment-related technology news. And he's covering this case. And it's been pending for a while, and his most current article about it notes that the Chamber of Commerce, which is this enormous, there are chambers of commerce throughout the U.S., but it's a private business federation, the nation's largest private business federation, sought to file an amicus brief in this case because it didn't like the fact, just like Vizio didn't like the fact, that Vizio moved to dismiss the case and didn't succeed in getting it dismissed. That motion was largely denied, partially granted, but the case is going to go forward. And what the Chamber of Commerce would like is for the district court, the trial court, to allow a direct appeal of its failure to grant that motion to dismiss. I think the chances of that happening, allowing a direct appeal before there's more litigation and a trial, I think are very, very remote. Courts don't usually do that. But that's what the Chamber of Commerce would like to see happen. And I assume Vizio has moved for that. So I'm skeptical that will happen. But in the briefing around this, there are some really interesting insights into how businesses are viewing this case and the broader ramifications that it might have. The plaintiffs are arguing that Vizio's practices, which are collecting information about what's being watched on the TV, is what's at issue in this case. And the plaintiffs argue that those practices violate the Wiretap Act and the Video Privacy Protection Act. Folks will remember that one from the Robert Bork confirmation hearings. It was enacted in direct response to people wanting privacy and what they were renting from their Blockbuster or other video cassette provider. So the Video Privacy Protection Act is admittedly a fairly creaky piece of legislation. The Chamber of Commerce is arguing that it doesn't have any application here because it never was looking forward to TVs that might be actually watching what you're watching. And they've provided some interesting insights into how the case is seen as a threat to other Internet of Things manufacturers and also, the entire Internet advertising industry, possibly. What they write is that plaintiff's core theory is that Vizio violated the Video Privacy Protection Act because it shares electronic information so as to facilitate the delivery of targeted advertising. Yet the business model of sharing information for purposes of targeted advertising is the business model underlying many of the Internet's most widely used services. That business model is ubiquitous in the Internet of Things, the network of physical devices connected to the Internet that collect data, and the court's decision may have major ramifications to such technologies, et cetera, et cetera. So just an interesting case to watch, this Vizio one about smart TVs, and just, another in the series of smart TV issues we've discussed on the show here in recent months. Drew, anything to add?
Other than I think Samsung was the other TV or smart TV case out there. I might be wrong, but I think that's what it was. Other than what was already discussed, I don't think people really understand the smart technology market and what the capabilities are, whether it's Vizio or the Amazon Echo, the Google Home, or whatever else is coming up. There's more to it than just the efficient ways of using it to get to Netflix or to whatever applications are, and there's always a way or there's got to be a way for these companies to understand how its consumers are using the technology so it can come out with better and more techie or fancy ways of using products. But at the same time, as I said before, where is that gray line? Where is that line drawn when it comes to targeted ads at a consumer? And should those ads be in a person's private home once they've purchased the TV? And it's a lot of different arguments.
Yeah, I think we're headed toward a real showdown on this question of what constitutes anonymized data and whether it's even possible to anonymize data sufficiently that it can be leveraged for advertising and other things. That's one of the things that they raise in their brief here. And it comes up in so many arenas. I remember seeing earlier this week, just caught my eye for a moment, that Amazon now has charts where they, top sales and what people are reading charts. And I don't know if people are paying close attention to the privacy ramifications of that, but it's sort of akin to what we're talking about here. Amazon knows what you're reading, your TV knows what you're watching. These companies are charged with making sure, presumably they're charged with making sure that people's data and again, back to Uber and its dossier of information about its users, that those dossiers are, not capable of being matched up with individual users and borking their Supreme Court nomination, for example. But I feel like the laws around this are, again, here's this lawsuit where consumers are suing Vizio. It's not like our regulators are doing a whole lot to make sure that this stuff is clear and the guidelines for businesses are clear and the consumers are being protected. I think it's all really in flux right now. As Eric Gardner points out in this piece, there was a recent settlement with the FTC that now prevents TVs from automatically collecting data on its users. Apparently now you have to check a box and say that's okay, but we all know that a lot of people don't really realize what they're doing when they check those boxes anyway. So I think it's kind of a mess, and it's going to come down to, what is anonymized data, and if we can actually determine that there is such a thing, what can you do with it? And I'm not sure exactly how that's going to play out, but do you agree?
I do. I think it's going to take, unfortunately, one of these cases or situations to go to court and actually see it play through and play out to start to establish what kind of standard governs anonymizing data, what data means, who owns the data, and what happens when data is taken into your personal home space or workspace. And, I have a TV back here. It is not a smart TV because I fear the day that my TV just starts talking to me, and you don't know what's going to happen. And I am all for technology. I have several smart devices in my house, my office, but at the same time, the standard, like you said, is in flux, and it's going to take a case or a couple cases to start to understand what the boundaries are or will be in the future.
Yeah, I think the device that is your TV talking to you has, been released pretty recently. Isn't it called the Echo Show? I was looking for Amazon Show. So, you've got the thing that talks to you coupled with a TV right there.
Right.
Of course, it's not showing broadcast television, but whatever is available through Amazon's video services. But it's pretty close to what you're talking about.
Right.
All right. Speaking of what you can watch on TV, let's move on to some entertainment-related stories. I'm realizing I haven't put any MCLE passphrases into this show yet. Let's make Pirate's Life for Me our first one, which has multiple meanings in the context of the story that we're about to do next. Pirate's Life for Me. We put these phrases in to the show in order to help people who are watching or listening to the show for professional credit in their field. If you're a lawyer, we've got some information for you on that at wiki.twit.tv. Find our This Week in Law page there, and there's a chart of the various U.S. jurisdictions anyway, and how you might go about submitting for CLE credit for watching or listening to the show. We'll put another phrase in before the end of the show because some jurisdictions like to know that you've actually watched or listened, and this is how we can help people demonstrate that. So a pirate's life for me here refers to, and back to ransomware here, everything's coming back to it in this show, the fact that there was a group, I'm forgetting the name of the group, but I'm going to pull it up here. There's so many of these now. It's the Dark Overlord, right? Same as the this new group is an as yet unidentified group hitting Disney over the next version of the Pirates of the Caribbean series, number 5 of that series. Apparently, they've gotten a leaked version of the film and are threatening to release it. The Dark Overlord was the group that leaked first one and then several episodes of the new season of Orange is the New Black. Netflix didn't pay them. Disney's not going to pay this as yet unidentified group. But so they're taking your advice, Drew. They're not paying the ransomers. And in India, at least several people have been arrested over this kind of an extortion kind of plot involving a movie there where they were able to someone tried to do it with the first iteration of that movie. And now, God, I'm going to butcher this, Bahubali 2, the conclusion, was subject to a similar extortion attempt, and they were able to track it back to a theater where, interestingly enough, it was not done in a cam sort of way. No one had put up their phone or other camera and captured the film that way. According to Torrent Freak, in this case, the original pirate copy had been made digitally. This means that someone had managed to get hold of the encryption key used to decrypt titles subject to digital distribution. So it was some sort of inside job with the theater, apparently, then attempting to hold the studio ransom over release of that. So we had actual arrests there, and I'm sure that Netflix and Disney and others are hoping that something similar happens in the case of both the Pirates movie and Orange is the New Black. Drew, what do you think of this ransomware trend sort of everywhere?
Well, first off, to anyone who thinks that they're going to extort Disney, it's a problem. I think in this, we're in a digital age, and I don't think, I hate to be negative, but I'm trying to be realistic at the same time. I don't think it's ever going to truly stop, and it's just a matter of what methods are being implemented in the sense to better protect the films, the music, the TV shows. And a lot of times I think it does come from within the industry, and a lot of times with, right before the award shows, whether it's the Grammys, the Academy Awards, the Emmys, you start to see a lot of articles coming out about leaks of these movies. And I think the freedom to share and exchange information is great, but at the same time, people are so accustomed to having instantaneous gratification of movies delivered to their home via Netflix, through the iTunes store, the Android market, or, whatever platform you're using. And I think that is a lot of the excuse or arguments for why this is okay. Working in intellectual property law, I don't agree with it. I think, whatever's able to be done to protect the copyrighted work of the actors, the actresses, and especially the production companies and producers, it's a tough job to kind of maintain, because you don't really know where it's coming from or who's doing it.
It's sort of ironic too that Netflix is one of the, and regarding its original programming too, is one of the targets of this kind of a plot, because Netflix, unlike the traditional Hollywood model, doesn't window its shows, doesn't delay them. When they're ready, it releases them. You get them all in one big chunk. So, I mean, it seems like what could be an artifact of this kind of a strategy is for studios to do away with windowing, because they want to just get the thing out there in a legal way as soon as possible and make it so that, people don't have to seek out pirated released copies, but Netflix does pretty much all it can. It's ready. We release it. It's done.
It's the binging withdrawal defense, people always want more and more and more. And when that last episode, hits, you don't know what to do with yourself, so a lot of these people in this area that are, for instance, in this example with the Orange is the New Black and Pirates of the Caribbean, at least with Orange is the New Black, it has such a strong fan base, and a lot of these shows have such a strong fan base that the way it's released all at once at midnight on a Wednesday or Thursday night, it consumes people for quite some time, and a lot of people get so heavily invested in this type of media that, in their opinion, they're doing a sort of justice, I guess, for fans all over. And I've seen that argument a couple times. It's never stood ever, but that's just part of the binging era, or the digital downloading of society today.
Virgil in IRC is making a good point, though, that even though Netflix releases everything when it's available, it may not release it everywhere. That they still geo-block in different places, so that you might not get access to Orange and is the New Black in some country where here we would have it. So I guess leaked copies could still be something that would be sought out. But sure. I wonder, though, if it's not, if they are seeking to do away with geo-blocking and windowing, if this isn't counterproductive, because just like, and of course, probably all they're seeking to do is profit here. But if there is some sort of greater philosophical reason for this approach, I think that what these blackmail schemes are counterproductive to it, because just like they're not going to pay the ransom, would you change your unpopular business strategy simply because some criminal asked you to? Probably not. So I don't know how I don't know how effective that would be. Okay, I promised I was going to lighten things up toward the end of the show. This is our effort at doing that. This is just a wonderful story. Speaking of movie theaters, that was a close runner-up for our tip of the week this week. And if it were a tip, it would be several-fold. Don't sue your date would be one of them. Don't take your date to a movie on a blind date. Perhaps don't hook up with someone via an online dating site, though too many people do that for that to be a tip. Anyway, what happened here is a couple did all of those things. Man and woman met via an online dating site. They decided to go see Guardians of the Galaxy Volume 2. The woman was texting during the movie. She says just 2 or 3 times, but it drove her, first-time date crazy. He asked her to please leave the movie if she hadn't felt the need to continue to text. She did so. She had driven them both to the theater. She was so pissed off that she just left. Left him there. And the guy, though, rather than just chalk it up to being a bad date, sued her. Didn't have very good legal counsel. Probably he's suing for the cost of $17.31, the cost of his ticket to the 3D screening of the film. Clearly, he should have added to the damages the cost of having to get himself home from the theater as well, but didn't do that. And, I encourage everyone to go read this piece at Screen Crush. It is so funny detailing this lawsuit. The woman has somehow managed to remain anonymous and apparently is seeking some sort of protective order against her date, who continues to try and call her and try and get money back for the ticket. And the folks at Screen Crush who wrote this up, Britt Hayes is the author, went so far as to go on Yelp and delve deeper into the atmosphere that this all took place in. And the Barton Creek Square Theater apparently has some very dismal Yelp reviews. Writes, yes, it is one of the worst theaters in Austin. Everyone has a story about that theater, and more than one of them involves rats. So just
Yikes.
Date gone bad in the worst way. And as if that weren't enough, James Gunn got wind of this, creator of Guardians of the Galaxy, saw the Screen Crush piece that I was just referring to, retweeted it and captioned, "Why stop at suing? She deserves jail time," for texting in the middle of his wonderful film. So there we have lightened things up for you and let you know that, apparently suing your date for texting is a thing now. So watch out for that.
Not all Texans are like that, Denise. As a Texan myself, we don't always respond like that. So I can't speak on behalf of everyone like that. But
I hope that the alternative would not be to respond in an open carry kind of way either. So,
of course not.
At least he's using the judicial process.
It's true.
So, that's a good thing. All right. So we can't end the show this week without letting you know, bringing you up to speed on what's going on with net neutrality. Not to bring things down again, but I promise we'll bring them up again by the end of the show. So let's look at that bit of legislation, regulation, and policy important news that happened this week. So yesterday, the FCC started the process of undoing the open internet rules that are currently in effect, the net neutrality rules that are currently in effect. We have covered this issue on the show over the years since 2008, 2009, and then in 2010 when the first version of the open internet rules were enacted. And just in a nutshell, what's going on here is this whole the existing open internet rules exist on the premise that the FCC has the legal authority to enact them, first of all. And that's one thing that's under fire here. And secondly, if it does have that authority, should it even be doing anything to oversee ISP behavior when it comes to blocking or throttling or favoring internet traffic? And both those things are coming into question. Following Thursday's vote, that's yesterday, we will be basically reinitiating all those legal debates and relitigating, although that's not quite the right word, relitigating in the forum of the FCC, the extent to which the FCC has that authority and should be blocking or throttling or allowing people to favor internet traffic. So that process has all gone into motion as of yesterday. One of the FCC commissioners, the one in the minority here, Mignon Clyburn, said in the hearing yesterday, while the majority engages in flowery rhetoric about light touch regulation and so on, and appears to be no touch regulation and a wholesale destruction of the FCC's public interest authority in the 21st century. So that sort of tees it up from the opposition standpoint. And the ISPs here are basically saying, trust us. Comcast Senior Executive Vice President David L. Cohen has a quote, especially in the current heated political climate, we must come together from across the aisle, both public and private sector, to find common ground that protects consumers on the core elements of net neutrality without unnecessary and harmful regulatory overreach. So whether they're saying we'll do it without any regulation or we need to have regulation that's less extensive than what we have now, I'm not quite sure what to read from that quote. But the upshot of it is that over the summer, the FCC is going to be seeking comment before putting together a final new set of net neutrality rules, likely in the fall. And Commissioner Ajit Pai has said he wants to complete that rulemaking process this year. So if you remember back a couple of years when people were arguing for the FCC's authority and for the fact that the FCC should exercise that authority here, we're going to go through all of that again over the summer. And getting back to hacking and defensive security, one of the things that has come about in the course of just the vote that happened yesterday is there are allegations that a bunch of bots spammed the FCC site with fake comments about this. So the FCC is going to have to get things together and make sure it can handle and suss out what's fake and what's not fake, and protect against abuse and people just not actually weighing in on the issues, but maybe trying to manipulate the system or just be insulting or whatever, because all of that seems to have happened in the course of this process. And it's a really important issue. And if people can't make good arguments to the FCC about it, then we're probably looking down the barrel of net neutrality going away. So, Drew, what do you think about this bit of news?
I think there's good arguments on both sides. It's, in my position, it's very difficult to, A, choose a side, but B, try to predict where it's going to go. And I think we all can agree in that, there should be some sort of fair treatment for, all types of web traffic when you're online. And when you have the ISP that provides you with these services, again, what is the role, or what should their role be? And I think it's a similar theme of what we've talked about today, in that, it's going to take some cases like these and, silly situations and arguments to start to establish digital boundaries for cyberspace, whether you're dealing with ISPs or, online businesses, whatever it may be. There's a different set of rules that can and do apply that don't exist in the physical world. And I think there's a constant struggle between the laws that we have in place already and whether they're just as effective in cyberspace. But I think the FCC is doing what it should do right now and staying true to, making sure that there is some sort of regulation. And, if ISPs are willing to work together with the FCC and consumers to say, hey, look, yes, we're providing you this service, but we understand a lot of the concerns. How can we rewrite the rules in a sense? So I think it's going to take a little bit of time for us to really see the effect of it and the positives in it.
Right. CRL and IRC is saying it's not really that hard to understand. The ISPs want to control access to the internet. Yeah, I agree with you. And they want to be able to come up with pricing models that make the most sense for them and their investors, and not necessarily for startup video services or consumers. So, I find myself torn on the issue too. I very much come down on the fact that we need net neutrality, but I also would like, the regulations on ISPs to allow them to experiment a bit with different pricing models. That's a good way to help consumers sometimes, if there's competition and different avenues available. But when the competition takes the form of, we're getting huge payments from certain providers, so we're going to favor their traffic. And anyone who's not making us those huge payments, we're not going to favor their traffic. It's not a good situation. So this is all underway. People watch this space, and I hope that the FCC can get its comment process under control so that it's actually getting a good taking the temperature of the American people and their representatives, et cetera, and the policymakers who are deep in the weeds on this stuff. And there are many, many very smart people who are deep in the weeds on this stuff to help them make the right decision in the fall. Onward. We don't have a unicorn chaser for you on net neutrality, but we have a kitty cat chaser, our animal selfie of the week. So as I was telling Drew before the show, and I will tell any of you who are not regular watchers or listeners to This Week in Law, we do an animal selfie of the week in honor of Naruto the macaque and various issues and pieces of litigation that have sprung up around the issue of whether animals can own rights in intellectual property, whether they when they are the photographer or the subject of various photographs. So SJH_Canada, thank you very much for pointing us to this lovely kitty cat owned by Twitter user Thrill of Love, who has discovered the joys of animal selfies via the iPad. And Victor in the studio, if you click on that, you can see there's a whole series of photos. There we go, of Kitty discovering and then taking its very first animal selfie. And the Copyright Office would say that Kitty does not own copyright to this iPad selfie of itself, but PETA may beg to differ, and never the twain shall meet. But we will keep bringing you our favorite animal selfies, and please keep bringing us the animal selfies that you spot around the web. Thank you, SJH Canada, for giving us our animal selfie of the week. We have a couple of resources of the week for you. One is a piece written by Drew, a law review article. And if you're someone interested in the law of augmented reality, I definitely encourage you to check it out. It is in the Review of Intellectual Property Law from the John Marshall School of Law, and it's called Gotta Catch a Lawsuit, a legal insight into the intellectual, civil, and criminal battlefield Pokemon Go has downloaded onto smartphones and properties around the world. We've actually Drew a whole episode of this show on Poke Law and augmented reality law more generally, and it keeps coming up from time to time. So I'm happy to know that you've dug deep here in your law review article. Is there any one sort of takeaway that you want to highlight or leave folks with to tease them to go download the piece?
You know, I've played it a couple times. It is fun, but just, you know, have fun, but just understand what you're downloading, understand what you're getting yourself into. And as long as you're smart about what you do, you know, these things and these games should be fun.
They should indeed. I'm looking forward to the Harry Potter version that wasn't real.
Yes.
That would be very fun. Yes. Okay, so we actually have one more resource of the week for you. Just something to check out. Something I was pitched in email and clicked on and thought looked interesting enough to share. It's called lobbyforme.org. And as near as I can tell, you know, you can go to somewhere like EFF or other advocacy groups, and they are coordinating ways that you can get in touch with your representatives and let them know how you feel. What lobbyforme.org is, it lets you step into that role of being EFF or you know, another advocacy organization and start your own campaign and get people to rally around whatever your message is. Now, getting back to the comments that were being submitted to the FCC and the spam bots and all, I do think, I don't know much about Lobby for Me, but I do think that they are controlling what campaigns are actually going to be sent along to representatives. What they do is they have people leave voicemails for their representatives, and then they deliver the messages directly to the representative's phone. They anonymously publish the constituents' messages to their representatives. They are accessible to the public and sent to the media, keeping politicians accountable. And their analytics tool allows you to track your campaign's performance, and you can use this data to measure impact, prove support on the issue that you're lobbying for, and inform future action. So it's kind of a cool looking tool, but I'm hoping that they're exercising some support. They have this great example of the kind of campaign you can create, but they say, go ahead and leave a message in favor of this one. We won't send this one to your reps. So I hope that they're paying attention to others that people are going to create that are going to be equally as ludicrous as "Make Daenerys Queen" is their example, where Daenerys Targaryen is argued to be the rightful ruler of Westeros, and if you agree, you should leave your voicemail and say why you think so. Danny is. You may have already. Danny is the person most likely to bring peace and prosperity to the Seven Kingdoms. So I could see this being a real problem if all of our elected officials were being pummeled with campaigns about electing Danny ruler of Westeros. So I do think that Lobby for Me is probably exercising some discretion about what they pass on. But something, if you are interested in creating something meritorious to have discussion with your representatives, give it a try. And if you are interested in presenting something a little bit more mischievous and they let you do it, I'd be interested to hear that too. So keep us posted as you play with this thing. Our tip of the week that won out over don't sue your date is when FAA regulations are too onerous, just microsize it. That is what DR1 drone racing has done. We're going to show you this video on the set of Firefly. I'll give you the audio.
Champion.
I am worried about my arch nemesis, Hayden.
He's going to catch him.
I've never flown a truck like this.
I actually feel like you're flying in a spaceship.
Oh, they're back in it.
Look at it.
A racetrack that's out of
It's the Firefly set.
The comeback is complete. Yes.
It's like a video game.
Contain yourselves.
This is going to come
But
down
you
to
see,
final
the
lap.
drones are little teeny tiny drones.
Right now.
So we've talked about the FAA drone regs a lot on the show, and one end run around them from DR1 Racing and Air Hogs, who have launched this micro drone league, is just to get super tiny about it. These little tiny drones fly under the radar, as it were. The press release on this said, unlike previous full-size drones, this brand new racing format uses first-person view FPV drones that are small enough and safe enough to fly anywhere according to updated FAA parameters. So that whole thing about whether you have to be line of sight and whether you have to be a spotter goes out the window if you're flying something this tiny. And now there is a whole drone racing league about it. So kudos to DR1 Racing and Air Hogs for finding a way to work around the drone regs and let people race. Of course, they're not doing away with their full-size drone racing either, but this is just something they're playing around with, and they're playing around with it on the Firefly set too, which is super fun. Drew, do you pay attention to drone regs at all?
A little bit. I'm not too familiar. I mean, I'm still in that phase of, it's all really cool, but it is something new, and I look forward to seeing what else comes out about it.
Yeah.
But there certainly needs to be a lot more regulations on, the uses. I remember I was at a concert last summer, at a complex I live at, and somebody wasn't able to go to the concert, and you just see a little drone flying above the show recording until, officers found the person and got rid of the drone. So that's the extent of my involvement with that up close and personal.
Well, Boz in IRC is saying this is called a loophole. Yep, and I wonder if the FCC will do FCC, getting my acronym agencies confused. FAA will do anything about this at all. So watch that space. It's always interesting to know how the drones are being regulated and what's being done in response. So Drew, it's been so great meeting you and chatting with you today. Thanks so much for joining me on the show.
Well, thank you so much for having me. I had a great time. Definitely some great topics.
We plugged your law review article. Are you speaking at anything soon? Anything we should let folks listening and watching know about that's going on in your life?
It depends on what's going on in the week. I try to catch on to as much as I can as early as possible. So it depends on what's going on, but I promise I'll keep you updated with things going on.
Great. Thank you. And we've had your Twitter up all during the show. For anyone who's just listening and hasn't been able to see that, it's at Rossow, ROSSOW Esquire ESQ on Twitter. So great place to follow Drew. Or if you look up Andrew Rossow on Facebook, you'll learn more about Andrew's law practice and what he's got going on. So it's wonderful to have met you, Andrew. I've really appreciated the ability to go through all these complicated and somewhat scary issues with you here today.
Very much so, and thank you so much.
We need a second MCLE passphrase for the show, and thank you, Boz. It's going to be, this is called a loophole. So if you are listening for MCLE credit, you now have your 2 passphrases. Write them down. What else should we tell you? We should tell you that we record the show every single Friday, and except on those Fridays when we don't record the show. Last week was one of them. But most Fridays at 11 o'clock Pacific time, 1800 UTC. If you go to twit.tv/live, you'll find the show streaming right then and there at that time. But don't worry if that time doesn't work out for your schedule. You can always catch our shows when they are archived. They're available on YouTube. They're available on our website, the entire archive of shows going back to our inception in 2006, I believe it was. So it's fun to go back into the archives and see, you might want to dredge up some of our old net neutrality shows from 2009 and 10, and then again from 2013 and 14 to see where we've been on this issue. Gigi Sohn has been on the show before. She's a great person to dredge out of the archives and listen to again. So do appreciate your joining us however you do. If you do go over to twit.tv/twill, there are various suggestions of how you can enjoy the show at your leisure on whatever device that you choose. What else should we tell you? You should get in touch with us between the shows. I'm Denise at twit.tv. Matt is Matt C at twit.tv. And Mike Keys is Mike at twit.tv. Please email us. Let us know what's going on with you. Send us your suggested animal selfies or guest suggestions or anything that's on your mind triggered by what we discussed or what you would like to hear us discuss on the show. We love hearing from you. You can also find us on Twitter and on Facebook. Great ways all to get in touch and give us your feedback on the show and where you think we should go next. It's always a work in progress here, and we couldn't do the show without you. So thank you so much for participating and giving us your thoughts. Andrew, can't thank you enough for your time today and all your great thoughts and insights.
Thank you for having me. And just a real quick update from some Texas sources. I think the date gone wrong with Guardians of the Galaxy, the woman has finally come forward, and her name is Crystal Cruz.
Crystal Cruz, that's got to be a pseudonym. Who is named Crystal Cruz?
I figured I'd provide the
awesome.
update, but there's some articles going around.
That's fantastic. Well, good. I'm glad she's come forward, I guess. And
yikes!
I hope that they're able to work out this really crucial dispute in an amicable and professional way.
Says she agreed to pay the man, and the lawsuit has been dropped. Texas news sources. So that's Texas sources. So I'm just reading what's going on, but
that's fantastic. They were able to work it out in an amicable and professional way. Should your Texas news sources prove to be true? Well, that's wonderful news.
Thank you again, Denise.
Thank you so much, Andrew, and thank you all for joining us. And we'll see you next week on This Week in Law. Take care.